At 9 a.m., I'm going to call the Judiciary Committee to order, and would you please join me in a pledge of allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, I'm going to open the public hearing on Senate Bill 414, and the chair recognizes Senator Abschel, the prime sponsor of the bill.
Good morning.
Morning.
I will fill out my red card.
Oh, yeah,
when I'm
that's
done.
fine.
I'm so
Thank you.
sorry. I just realized, I haven't done that yet.
No problem.
And I have passed my testimony up. Good morning. Thank you, Chairman Lynn and honorable committee members. I am Deborah Altschuler, and I represent Senate District 24, which includes the towns of Exeter, Greenland, Hampton, Hampton Falls, Northampton, Rye, and Stratham. Senate Bill 414 addresses an ongoing deficiency in the judicial system. Over my past 3 years in the Senate, I have had multiple women reach out to my office with the same exact problem. They have sought legal relief after being granted divorces. All of the women who contacted my office had their own unique experience, but one unifying theme is that the courts had failed them. Judges for alimony, child support, health insurance, homeowners insurance, all court-ordered to be paid, were left ignored. So what can you do if you've been granted a divorce and granted all of these things, and one party is ignoring their responsibilities, often to the detriment of the other party? You go back to court and you file a motion of contempt, and then you wait. You wait for a hearing that can take months to schedule. Meanwhile, your bills are piling up. Perhaps to bridge the financial gaps, you take out a credit card debt, anticipating that the courts will, of course, back their original order and force your ex to abide by court orders. Then the hearing comes, you and your lawyer, who you also owe enormous legal fees to, but they've been accommodating in your payment schedule because they know you still have to pay the mortgage, health insurance, and all the bills that your ex has been ordered by the court to pay in the final divorce decree. But the ruling doesn't happen on the day of the hearing, so you wait. And an order is granted, and again, in your favor, but no enforcement. So you start the process all over again. One phrase said to me by one of the women abused in this unending legal foolishness that sticks with me every time I learn of another of these situations is, why am I being punished for my ex's bad behavior? And indeed, why? Senate Bill 414's power is on line 4. The court shall fashion a remedy that immediately rectifies the cause of contempt, allowing contempt to go on and on and on indefinitely, with the only consequences being for the aggrieved party, is unjust. I respectfully ask the committee to recommend Senate Bill 414 ought to pass and hasten the relief of granted staters caught in the labyrinth of our legal system. And I'm happy to take questions.
Questions for this witness?
If I might.
Yes, Representative Birch.
Thank you. If there's something you wanted to say.
I can defer to answer your question.
All right, thank you. I understand the bill, first of all, only deals with after somebody's been found in contempt. Is that right?
Correct.
So the earlier part, waiting for those hearings, is not what this bill addresses.
It is not.
And if I could follow up?
Yeah.
The remedy, I'm focusing on two words, immediately 3 words, and if practicable. So my question about the value added in real life in this bill. If it's up to the judge to decide the remedy and how it's to be applied, the judge is necessarily doing if practicable. The judge decides that, what's practicable and not. Is that right?
Well, it's been the experience of the people who have come forward to my office that that is not the case.
No, I'm talking about the bill. If I could
I'm sorry.
check. What the bill requires
Yes.
is that the judge do certain things if the judge thinks they're practicable. How
Yes.
does that change anything?
So there are avenues available to the judicial system, like garnishing of wages, liens. None of that in the people who have come to my office experiencing the quite frankly the abuse of court continuances and ignoring of court orders. None of that has been used. So while that may be an opportunity for the judges to get relief for people who have been marginalized, it's not being used. And so we felt that we needed to put in a little stronger language that if practical and immediate.
Other questions?
So I'll give you the example of why. We had one of the women who is experiencing this. As you may understand, I had 3 women who have been actively talking to. 2 of them were very reluctant to come forward because their cases are still pending and thought that it might in some way upset the tea kettle within the judicial system. They have been so abused by the system that they are frazzled, and I understand that. But I have one woman, Susan Schwartz, who testified, and she defined the coercive control and how it appears through financial abuse. And she stated that while she had to wait for her trial for divorce, which was delayed to the pandemic, she had accumulated $120,000 in credit card debt. When the divorce was granted, and it was granted for infidelity and abuse, she was granted a large settlement that was backdated to cover those expenses. He then appealed to the Supreme Court, which continued the cycle of Ms. Schwartz not being able to access any of their marital funds and assets. And while this is going on, her ex is accumulating more and more assets. So we were asked during the Senate committee, well, why didn't, and this has gone on for years, and just Monday of this week, Ms. Schwartz had to close on her home because she had to sell her home to make up for her legal bills, and she couldn't afford her mortgage anymore. And meanwhile, there is still almost $250,000 outstanding in back alimony and other fees that are due to her. And she was asked, well, why didn't you file a complaint against the judge? Because that is an avenue open to her. And like the other women that I have encountered through this process, she was very, very reluctant to file a complaint against the judge who's still in charge of her case. And because even though it's going horribly wrong, as someone who's experienced the judicial system going horribly wrong, she also knows it can get worse, unfortunately. So she has decided not to file a complaint until this case is resolved. And, that is something that I've heard over and over again. So, she's now homeless and still awaiting over $250,000 in fees and what is owed to her in back alimony. Meanwhile, her ex files continuances and continues to live his life. And there's no remedy for her other than to file another contempt and wait. But now she waits in a hotel room.
Other questions for this witness? Yes, Representative Anders.
Thank you, Mr. Chair, and thank you, Senator, for taking my question.
Certainly.
Will this bill absolutely speed up the process?
Will it speed up the process of distribution of assets?
Yes.
This bill will address once a party in a divorce has defied the court order. It will not allow, but it will force the judge to take immediate action, not just assign another ruling of you really need to abide by this court order. And it will allow for putting a lien, or it will encourage the judicial system to take stronger action. The actions that are being taken now are not enforced. They are, and the other parties have been abusing the system. It takes a long time to get a hearing. Emergency hearings are not, there's not a lot of urgency in emergency sometimes.
Thank you.
Yeah. I would like to add that this passed through the Senate Judiciary Committee with a 5-0 ought to pass, and then passed on the floor on a voice vote.
Yes, Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question.
Yes.
Your testimony seems to indicate in this one particular instance that the delay in the lady getting her payment is due to continuing court issues. Now, does the man not have a right to question the judge's decision and continue the court processes?
Of course, and there's nothing in here that interrupts that. What we're talking about is in the case of Ms. Schwartz, there's a final decree, and it came from the Supreme Court, a final decree, and her ex-husband was ordered to pay a certain amount of money monthly, health insurance, life insurance, and a portion of the mortgage payment. And this divorce had been granted on abuse. And so what his response was to just not pay it. So he just doesn't pay it. And so her only remedy is to go back to the court and say, the court ordered that these things be paid, and they are not happening. My health insurance has been canceled for non-payment. The homeowner's insurance is being canceled for non-payment. I am not getting my alimony, and nor am I getting the portion of legal fees. So we need the court, though she is asking the court to enforce the order that they had already given. And the answer was, we'll take it under advisement and get back to you. And in the meantime, this goes on for 2 years. At what point does the person who has been ordered by the courts to do something, which in this case is to pay, have to actually abide by a court order? After the appeals are exhausted, we are not talking about pending appeal. It's exhausted.
Thank you.
Yes.
Yes, Representative Turner.
Yeah, thanks, and thanks for taking the question. So I guess from the last story and the general thought here, is the issue with the way these cases are playing out, the fact that the judge in the case is not using all of the powers that they might have to compel someone in a contempt finding to begin with. Like, I would imagine if they're found in contempt, they could do anything from garnish someone's wages to jail them to, do a lot of things. So I'm wondering,
Yes.
I see this has the word that the court shall fashion a remedy. So is this trying to essentially compel the judge to do something that they're not doing, or does this have to do with the spouse?
No, this is the judge who is not taking advantage of the opportunities that, or the tools that they have to compel an order be followed. And this legislation was brought forward because the experiences of the people that I have worked with are not just one singular judge. Were that the case, in fact, the first person that came to my office 2 years ago, our office, and through the help of some consultation with legal aid and asking around, like, how do we help this person, it eventually came to what we have available is to file a complaint against the judge because the judge is not enforcing the orders that they are being given to this other person. And then it came up again and again. So this now appears to be a trend. If it were one judge, I wouldn't be coming here and pushing forward legislation to address one person's experience, but it's not just one anymore.
Could I ask one follow-up?
Sure.
I guess, and maybe I'm building on what Representative Birch started asking, which is, does this then give that judge with the language that's in here still quite a bit of discretion in terms of what they do once we say that they shall fashion that remedy?
Yes, I mean, what the remedy is still in their control, but they need to take action to fashion a remedy and not just let this continue or assume, or the good faith of the other party, that they will eventually abide by a court order. The assumption that everybody would abide by a court order, is a generous one these days, if, at that, very generous. Otherwise, you wouldn't have this in front of you.
So I wonder if I could just ask a couple
Yes,
questions.
sir.
So if, I guess the thing I'm not clear on is, in the cases, I mean, I understand you had complaints from a number of constituents
Yes.
about, and I completely understand. I guess my question is, have you taken, in any of these cases, have you had an opportunity to actually review like the hearing transcript or anything like that, or talk to the lawyer or the party on the other side? Because what I'm wondering is, I mean, it strikes me as odd that not only one judge, but a series of judges would not enforce a court order unless there was another side to the story. And so, in other words, it just strikes me as, why would a judge do that? If the situation was just very clear that somebody should be, for example, ordered to jail today unless you turn over certain money or assets or whatever. It strikes me as odd that a series of judges would do that unless there was another side to the story. And so what I'm really asking is, do you know if there is another side to the story?
Mm-hmm. Thank you very much for asking that question, and particularly in the way that you asked it. The threat of jail time or garnishing of wages in the 3 cases that have come to my office has never been put forward. So without a threat of some sort of penalty other than just pay the court, and very stern warnings in the court, nothing gets done. And with regard to, I have unfortunately read volumes and volumes of dockets and orders and motions. And it boggles the mind as to why someone who has, in all 3 cases, have already been granted divorces, and there is a divorce settlement that says who is supposed to get what and when. And those orders are not followed. I am absolutely flabbergasted at the way some people who are dealing with the courts thumb their nose at a court order and believe that if they fool around with motions to extend, or I can't make it on this day, or all manners of excuses. And I recently, Miss Schwartz actually just sent me the latest motion that she has given to the court, because now, and it's an emergency. She filed an emergency request because she had to close on her home on Monday, and has been waiting 3 months since the last time she asked for relief from the courts for what was supposed to be a final divorce decree 2 years ago. So she's massively in debt, no health insurance, homeowner's insurance was gone, now the house is gone itself, and her jobs, don't cover any of this. She was left financially destitute.
Representative Birch, did you have
Thank you again, Senator. You mentioned the divorce was final
Yes,
numerous times.
yes.
Is it your understanding that regardless of the use of that language, that divorce decrees are modified frequently after the original framework was approved by either courts or both sides, and that parties have a right to go back to court and say, this fit isn't good, or this is a problem, or this is a financial problem, or what appeared good 6 months ago doesn't work now. I am curious whether, since the judge already has the powers you described to put somebody in jail, to put liens, to order financial transactions, to do a wide range of things, again, what does this bill do other than say, Judge, you should consider doing those if you decide it's practicable? And I use the word shall consider instead of shall, because the words if practicable remove the mandatory aspect in this legislation. Would you not agree?
Thank you for turning the kaleidoscope a little way. Indeed, I am aware that after a final decree, there are opportunities for both parties to approach the court for modifications to the original decree. Yes. This is not that situation. There's been no request for modification from the other party in all 3 of these instances. The other party has just walked away. So they don't pay what they are ordered to pay. They don't dissolve an asset that they are ordered to dissolve. And instead, in one case, used a boat to leverage a purchase of another play vehicle, while they are in arrears on paying their alimony. So when, if practical was a suggestion that not all parties can meet that financial obligation, and probably should ask for some review. The instances that bring me here to you today are all women who have been granted divorce decrees, the most egregious one for abuse, and the court has made an order that says you shall have this, and this. And the other party has said, I don't feel like it. Like they just don't. So what happens when they just don't do it? Like, yes, they should be threatened with jail time. Yes, they should have their wages garnished. I think perhaps a lien on the new property that they just bought. But none of those things are happening because there's no compulsion to do that. The cases that bring me here to you, I am again flummoxed as to why the courts do not take this more seriously. And so that is why you have on line 4, the court shall fashion a remedy that immediately rectifies the cause of contempt. Like, fix it now, here. Like, don't walk out of this room allowing this party who has flouted all orders to continue on this road.
Other
Now, I'm
questions?
open, if you want to take out if practicable, I'm open to that. You know, it's, I've now given it to the committee, so you can do what you like with it, but
All right. Other questions for this witness? Seeing none, thank you very much.
thank you.
Is there anyone else who wishes to be heard on SB 414? All right, seeing none, I'm going to close the hearing on Senate Bill 414, and we have a couple of minutes before the next one. All right, I'm going to call the Judiciary Committee back into session, and we're now going to open the hearing on Senate Bill 519 FN, and the chair recognizes the prime sponsor, Senator Reardon. Senator, thank you.
Good morning, Chairman Lynn and members of the committee. My name is Tara Reardon.
I'm the senator from District 15, which is Concord, Bow, and Hopkinton. And I'm here to present Senate Bill 519, which is about drones and privacy. And the version that you have is substantially amended from where we started out on this bill. So drones, or unmanned aerial systems, as we call them in the law, literally was a 1.25 page bill when we started this, just with a section on definitions, a prohibition on uses that violate privacy, some exceptions and some remedies. And when I brought this on behalf of a constituent that this is important to, I heard from business and industry in a way that I had never realized how prolific the use of drones were. The reason for this bill is a technological gap in existing law. The proliferation of affordable drones creates new threats to privacy like physical trespass. Drones can hover overhead unseen, capturing imagery, audio, and data from private property. There was a lot of confusion in the Senate hearing about what is regulated by the FAA and what the state regulates. And the FAA, my research shows, FAA governs airspace safety and navigation, and it does not regulate privacy concerns. Drones in states are legally empowered and actually expected to fill the gap with laws that protect individuality and privacy rights. So public concerns of residents living near drone users, whether hobbyists or paparazzi-style operators, do not currently have clear statutory limits. And that risks intrusive surveillance and sometimes emotional distress. We see things about this in the paper all the time of residents who have seen numerous drones flying over their property, no idea who the operator is, what their goals are. And so this bill requires written consent for somebody to drive, to fly a drone over your property. Other states have similar statutes to this proposal, including Florida, which we relied on heavily for the wording here, California, Michigan, North Carolina, Ohio, and Indiana. So the goal of this bill has always been individual privacy protections. And once we had a public hearing, we heard from some of the people in this room of the prolific use of drones by business and industry. So it changed our definition of surveillance and the exceptions that we had. We worked with and modified the bill to include law enforcement, and I know Trooper Ball is here. We never took in the point of view of them doing an investigation. This was always written with a point of view of an individual's privacy. So after my conversation with him, we probably do need some tweaks to it. But the people that rely on them are utilities like Eversource, broadband carriers, dams, railroads who survey critical infrastructure, appraisals of property for tax assessment, environmental emergency assessments, and insurance companies either doing premium calculations or claims work. I spoke to WMUR at the insistence of someone in the broadcast industry. We reviewed this language and their existing language at RSA 644.23, and they believe that what they do now is absolutely covered, and this would not change it at all. So any party that proposed a legitimate business use for this, we accommodated in this bill. I would hope that the committee would look favorably on it, obviously still willing to fine tune it so it works for everyone. But I would be open to questions from the committee.
Questions for this witness? Yes, Representative Birch.
Thank you, Senator. I actually have a lot of questions. I worked on drone legislation with former Representative Kirk for several years, and we came across some problems, not only preemption problems, but First Amendment problems in Vermont Constitution, the New Hampshire constitutional problems. Taking an easy part first, let me ask about news gathering. Somebody has some property. There's, let's say, a newsworthy event going on. What I see on CNN or whatever, are these helicopters flying over and taking a picture and the like. This bill as amended would seem not to allow that without the permission of the landowner. Am I correct?
If I may, thank you for the question. I'll answer it in a couple of different ways. Drones are, the regulation of drones in the state of New Hampshire, they're not allowed to go over 400 feet in the air, and a helicopter at 400 feet would be extremely dangerous. Helicopters are 1,000 feet and more. So I would say that this would not impact them. And Alicia McDevitt is the person I worked with at WMUR. She didn't seem concerned that our language would impact what they do under existing FAA regulations now.
Could I just clarify?
Sure.
I'm not interested in WMURs. I'm not interested in height. I'm just saying, is there an exemption in the proposed language for First Amendment activities?
So I believe the standard in law now is that you're able to, whatever you're able to see from a public right of way is what you're entitled to see. Otherwise, the landowner is entitled to privacy in their backyard. If you can't see their backyard from the street, then you can't fly a drone over it, is what this bill says.
Just to clarify, there's no First Amendment protection here for news gathering and other free speech type of activities. If we're clear on that, I'd perhaps can, if no one else has any questions, I had wanted to ask about that observable from public ground level point.
Well, go ahead. If you have another question, go ahead.
Yeah, as I understand, and thank you for taking additional question, the New Hampshire Supreme Court, of course, invalidates statutes where people of ordinary intelligence have to guess at their meaning, or there might be arbitrary or discriminatory application. So if I understand correctly, your standard in this bill is whether property is observable from a public ground level vantage point. And my question has to do whether that is inherently unclear, given that visibility can change with topography, vegetation, structures, season, lighting, and is ultimately to be determined actually subjectively by courts and enforcement bodies. Would you agree with those problems?
I would agree that the plain meaning of what you can see from the public right-of-way is about as common language as we could hope for. And I agree that all of those things could impede your sight line into somebody's backyard.
And regardless of common usage, if laws are made that could have criminal and civil penalties, you would agree that the courts, such as in the Mackelman case, the statutes have to provide objective, enforceable standards. Would you agree?
I'm not familiar with that case. I'll take your word for it.
But as the general proposition, that if you're going to enforce statutes criminally or civilly, the statutes have to be objective and enforceable.
Sure.
So let me ask you a question. I'm flying my drone, and on a good day, where it's clear, I can do certain things and not. And if it's a foggy day, I guess it's different. Is that right?
I've never operated a drone, but I will.
I'm talking about the standard here
Okay.
of from visible from a public ground level vantage point. That would vary from day to day, even whether it's a snowy day, a rainy day, or a foggy day. Is that right?
Mhm.
And I would have to guess whether that's legal or not. Is that right?
Or the court would have to determine whether that was legal or not, if in fact somebody pressed charges on you.
If I may. But
Sure, one more. Go ahead.
some of the statutes I looked at, and California and Texas seem to be leading in this area.
Mhm.
Both of those statutes have a requirement that if there is improper intrusiveness by a drone, that it has to be intended. It has to be willful. And in both of those states, it has to be for a bad purpose. So there's scienter, there's a requirement of bad intent before you're criminally or civilly liable. So am I correct in understanding, let's say somebody has 1,000 acres of property and you're an adjoining owner and you accidentally go 10 feet over somebody's property in the middle of the woods, that this statute, unlike in other states, is a strict liability. You have committed a crime or you have committed a civil violation that can get you sued, whether it was accidental or not, no intent is required.
I think it does say knowingly, at least in the criminal offense. It does say knowingly, I think.
Okay. I may have missed that part. All right, then I'll withdraw that one.
Representative Tur.
Yeah, thanks, and thanks for taking the question. I actually did sort of want to ask about that, the new paragraph 3, where it introduces the Class B felonies, and there's two things listed, and the second one I think sounds pretty clear: knowingly distributes or publishes surveillance obtained. The first one, I guess I'm wondering, I'm looking at the word over on line 25 of page 3. And I'm sort of wondering, is the violation the thing that triggers a Class B felony, the fact that that drone was over a person's property? Because at any reasonable height, you can get the information, the pictures, the audio, the data that you're talking about, even if you're not over that person's property. It seems as though for a Class B felony, sort of just the sort of stepping over the vertical, boundaries of someone's property versus the actual gathering of the surveillance that I think sounds like is the intent of the bill. And I'm wondering whether that paragraph, because triggering a Class B felony for, crossing over someone's property line seems high. It seems more about what you do with the data you're gathering, whether you are or aren't over a piece of person's private property. Like if they go over the, conservation land next to my house and take a picture in my backyard, it feels like we're in the same territory. So I don't know if there's reason why it's worded that way.
I'm not sure of the hypothetical that you're giving, but I think with a trespass, existing trespass law, if you go over a line, not intentionally, but in error, then you've still trespassed. Whether you'd be prosecuted for that is a whole nother question. But this allows the expectation of privacy that we all have in our private property to just move up, to give you the air rights for your expectation of privacy also. So the likelihood that you would be prosecuted if you are out hiking in the woods and you trespassed onto that's the intent of doing something bad is not there. You probably would not be prosecuted. This is for the house that has a teenage daughter sunbathing in the backyard. That's the expectation here, that you are not entitled to see what happens behind a fenced pool at somebody's house.
Can I ask one quick follow-up on that?
Sure. Yep.
I maybe just to sort of clarify what I was asking. Paragraph 3, part 4A requires you to be over the property. The second part, 4B, is about distributing or publishing surveillance that you obtain. So if that information, those pictures or whatever were obtained by somebody not quite over my property,
Yeah.
you know, which I think is pretty common. There's, you know, you can see a lot from, you know, a few hundred feet up. You know, does that create essentially a loophole where, you know, you can just capture and distribute this information if you're not physically over your property?
So this has a knowingly standard to it. Both of them have
Okay.
knowingly standards, so you have to knowingly be over it. Could you be over the neighbor's property, or maybe you are the
That's
neighbor? You possibly could do this, but I think part of the intent of this bill is not necessarily the images that are captured, but the distress to a person who is in their backyard while there's a drone hovering that may come over here. So we can't necessarily ban somebody from using it over their own property, but we can set some guidelines about the property that the complainant owns.
Other questions? So I guess what I'm wondering is, I really have two questions. One, if, I think Representative Turner raises a very good point, but could we solve at least that problem by changing the word over on line 25 of page 3 to just of? So that includes an imaging device to conduct surveillance of private property. So in other words, and what that would mean is,
Mhm.
I think, even if you weren't technically over the property, if you were, you know, over the neighbor's property, but the camera was focused on the subject property,
Mhm.
that could still be a violation if the intent was to do what
Surveillance.
the surveillance. So that's why. But the second question I have is, and I don't know the answer to this, but I'm just wondering if this is something that's a problem. Correct me if I'm wrong, but it sounds like if you read the whole bill, what this bill is basically saying is you can't conduct drone surveillance of somebody else's property, unless there's a good reason to do it. And you list in the bill lists a whole bunch of good reasons why, for everything from law enforcement activity to insurance investigations, or, you know, searching for a missing child, a whole bunch of things that I think we probably would all agree are very good reasons. The question I have, though, is if it's okay to conduct surveillance of somebody's property for all of these good reasons, and I, as a property owner, kind of know that, you know, that there may be a lot of good reasons why somebody can use a drone to conduct surveillance of my property. Doesn't that really diminish my expectation of privacy, so that there really isn't one? In other words, if, you know, if it's okay, if all of these people who have quote unquote legitimate reasons can see, you know, the teenager sunbathing in the backyard, then is there really much of an expectation of privacy that to prevent anyone from doing that? That's really the question I have.
So, and I would answer it in two different ways. One is surveillance versus inspection. Surveillance is what we're trying to curtail, give some privacy rights to. Inspection is if Eversource is looking at their lines, they may capture somebody, and they're not there to surveil and constantly watch somebody who's at the swimming pool. Their goal is to survey their lines and look for deficiencies in their infrastructure. So I think the definition of those two words is important. And the second part that I will say is this bill started out with a mandate that anytime you captured a picture of a person in one of these inspections that you were doing, that you blur it. And there was a lot of pushback from a lot of industries, and delete the image as soon as possible. There was a lot of pushback from the industries that said, we save these, we compare video film of our lines over time. We want to know what's degraded. We save this. They're not open to the public. If there's a person in it, we're not interested in that. That's not their mission. Where and you'll see in two sections of the bill, I think it's the property appraisal. Those use of drones in those cases is to value that property. And those are public records. So we kept, and this is thanks to former Representative Kirk, we kept the language in there that if you have a person in those, you definitely blur them and you don't keep an image beyond when you were. So I think the use by business and industry to inspect lines is a totally different use, and those pictures end up, or those videos end up someplace completely different than what we're talking about here, which is surveillance, where you're looking at a property that you're not entitled to look at. There's a right of privacy in that property, as opposed to a utility, a right-of-way, a common line.
And yes, I'm sorry, Representative Manos. No, go ahead. Go ahead, please.
Thank you, Mr. Chair, and thank you, Senator, for taking my question. I wanted to explore a little further with you the concept that you use here of private property. And I'm wondering, I have two situations that I wanted to ask you about. For example, if somebody's living in public housing and they're in the recreational area of the public housing, that is not private property. So, but still people would have an expectation of privacy. So how would the bill apply in that situation, or would it apply in that situation?
I don't think I can give you a 100% accurate answer to that. In the definition of surveillance, it means with respect to an owner, tenant, occupant, invitee of privately owned real property. So in fact, if it was, an apartment building, even the tenants and the lessees would have rights to that. The rules about drones over publicly owned land are completely different. I'm not an expert in them. There are rules about where you can launch a drone from and things like that. I'm not sure I can give you an accurate answer as to what the rights of a person in a publicly owned space is.
Would you agree that the kind of situation I described where somebody's living in public housing, it could be an apartment building, could be individual units, that someone living in that situation should also be protected?
That would be wonderful if we could word that some way to make that right of privacy follow you into a public space, which is difficult, I think, to word.
May I follow up?
Yes.
The other question I wanted to ask you about is condos, where the land is technically owned in common by all the owners. And so, again, I'm not sure it would fit under the definition of private property, but certainly there again, if somebody is sunbathing or whatever, I think they would have an expectation that this kind of statute should protect them. And I wanted your feedback on that also, please.
I would say that a condo is privately owned property. It's just owned commonly by a group as opposed to one individual. And this would require written permission of the representative of the condo association to fly a drone over there. Or the board of the condo association would be my guess.
Thank you.
Other questions for this witness? I guess I'm sorry, Representative Smith.
Thank you, Mr. Chair. Good to see you, Senator. I'm interested that all the examples that have been given are examples of, in effect, teenagers, which by this we mean teenage girls or women, however, sunbathing. But aren't there other situations which should be kept private. For example, one that involves two individuals who are speaking to each other or, whatever. And I'm a little troubled, Senator, by everything coming back to teenage girls. I know, no one cares what an 85-year-old woman looks like sunbathing, but they do care about teenage girls. Are there other examples where people deserve privacy?
It's great to see you, Representative Smith, also. Thank you for the question. In the definition of surveillance on page 1 of the bill,
Yeah.
it includes any people that are there. And again, we did use the most kind of salacious example when I was giving that. But it applies not only to people who may be meeting in a space where you have the right to privacy, but also all of the physical improvements of that, whatever you might own that's in your backyard. And I think for privacy purposes, this applies not only to a person being observed, but maybe what you own and what somebody's intention is to make you part with what you own or something like that. I think there are a lot of reasons for privacy beyond who you're meeting with, who you are, what you look like. It could be what you own and whether that's subject to criminal intent also.
Thank you very much.
Thank you.
Other questions? So, yes, Representative Scully.
Thank you, Mr. Chair. I just did a quick search of our laws, and I think a physical trespass is a Class A misdemeanor. So what we're creating here is a drone trespass and immediately kicking up to the level of a felony. Do you think there's justification for making a machine flying over your property a more serious crime than actually physically going onto the property itself?
So I think physically going on to the property, you could be observed, you could be seen. When you send a drone over a property, it's a completely different intent and it's anonymous. You can't tell who's flying that drone for what purposes they're flying it. And the penalty requires it to be knowingly. So it is somebody sending up an unmanned aircraft over your property to observe or surveil, it has to be surveillance, for we don't know what purposes. So a physical human being, a witness could say, I saw him walk over that property and you've captured that person. That's easy, and it's easy maybe not to wander. I won't get into the trespass law, but a drone is a much more invasive and anonymous invasion of your privacy.
Follow-up?
Yeah, quick follow-up, thank
Sure.
you. I guess the other issue, my concern would be how enforceable this would be, given that the nature of the drones is they're operating remotely. So in terms of being able to associate a drone with a person and then being able to apply a criminal penalty seems to be a difficult proposition.
All right, other questions? So, Senator, I just want, oh, I'm sorry, yes. Representative Ball, sorry.
Thank you, Chairman Lynn, and thank you, Senator, for taking my question. I'm just a little bit confused. I'm not, and I apologize. Can you just explain how would there be any impact on recreational use of the drones when they're going over, say, like right now, I'm just thinking on a lake when people are water skiing or wakeboarding, oftentimes they'll put drones up to follow them, but they're going to capture the surrounding properties. So where would that fall into this in any place, or is that just allowed for recreational? I was scanning through this and I'm not exactly seeing where that would be.
Yeah.
Not fall into this.
I think in the definition of surveillance, it's the intentional observation of a person. So if you're following a water skier, you probably are going to see other people on the lake, and you're going by them at some speed probably. So it's not you're not intending to capture them. That
Okay.
It's incidental, and the same with privately owned real property. You're not scoping those properties along the lake to see what they have. but you are probably going to capture them. So I think the word intentional is key in the definition section under surveillance of both 1 and 2. And then subparagraph B there says it does not include the capture of, legitimate business purposes. If you were making a video for marketing purposes or something like that, then that's not part of your business purpose. It's just incidental to the taking the drone footage.
Thank you. And one follow-up, if I may?
Yes, sure.
So that's exactly what I had underlined was the business purpose, and I didn't know if it should also include recreational purpose, just to clarify that it's not just business, but also an individual. But I'll read it again a little more closely. I picked up on some of it, but it still left me with that question as to, I mean, it would be unknowing, but then that video could also be used for a nefarious reason that they may not know about if they post it somewhere. So I had a little bit, thank you for the clarification. Thank you.
Representative Birch.
Thank you one last time. I'm concerned, regardless about all this other discussion, the preemption issue under the FAA. And we've discussed earlier that the exclusive authority of airspace belongs to the federal government. So I'm wondering if in your work you had a thought about the federal court case in Massachusetts, Singer versus City of Newton. You may or may not be familiar with it. Just reading what my phone says, is a landmark federal case where Massachusetts District Court ruled that local drone regulations are largely preempted by federal law. Newton's ordinance requiring drone registration and restricting flight over private property conflicted with FAA authority confirming federal jurisdiction over airspace. I think one of the issues was that the city wanted to ban drone flights below or within 400 feet or whatever, and the federal court said that's federal, that's not state. So I'm wondering, given those kind of decisions, the U.S. Supreme Court in the Burbank case, which had to do with aircraft noise, where again, we wanted to do regulation about noise and at local or state level, and the Supreme Court ruled exclusive jurisdiction over these kind of aircraft issues are the federal government. How you deal with that when, again, it's a state trying to regulate airspace and create no-fly zones, which is something that the federal FAA has clearly spoken against numerous times.
So I have research that I don't have with me, and my understanding about federal preemption is, again, it's airspace safety and navigation. You do it safely and how you fly through those spaces, but specifically any privacy issues associated with that are left to the states.
Other questions? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Christopher Ball, please.
Good morning, Mr. Chairman and honorable members of the committee. Thank you for hearing my testimony. My name is Christopher Ball. I'm here representing the Department of Safety, specifically the State Police. I serve as our lead drone pilot currently. I've been assigned to our aviation unit for the past several years as well. I'm going to try to curtail or keep my testimony relative to public safety issues. I think there's just some important issues that need to be presented to this committee regarding this bill. Did have a good conversation with the senator prior to this. I believe this bill is well intended, and we understand the need to protect people's individual privacy. But there are some mentions of this bill regarding public safety issues that I think are going to be relevant to this committee. We use drones at the Department of Safety for all kinds of stuff. It's a new emerging technology, very, very useful stuff as regarding our job, search and rescue issues, um, crime scene documentation, assisting our tactical operations. There's many use cases for these drones, and I think there's even use cases that we haven't thought about yet because the technology is so new and so up and coming. So we use these drones quite a bit. So I just want to give the committee some understanding of some issues that might be presented with this bill. If I can direct your attention to page 1, lines 25 through 30. And again, if I'm speaking too fast, which I have a tendency to do, just let me know. This portion of the bill talks about the individual's expectation of privacy down towards the bottom of that paragraph. As Representative Birch had brought up, there may be some questions about how that is defined. Generally speaking, when we're talking about Fourth Amendment issues or Article 19 issues with the New Hampshire Constitution, a reasonable expectation of privacy generally exists in general understanding, private dwellings, inside restrooms, doctor's offices, things like that. When a person enters into what would be more of a public area, yard space outside of a residence, public areas, then generally speaking, their expectation of privacy is not quite as high as it would be like inside of someone's residence. I think we can kind of all understand that. This bill looks to define that reasonable expectation of privacy a little more narrowly. As you can see that it does define the expectation of privacy to be a reasonable expectation of privacy shall be presumed to exist in any location where a person cannot be observed from a public ground level position. The issue with that definition, and I understand from speaking with the senator that this definition may come from some case law, but as we can probably think about numerous hypotheticals regarding what would be an appropriate ground level position, as Representative Birch had mentioned, there may be many factors regarding what you can see, what you can't see, depending on the time of year, foliage, maybe vehicles that are temporarily there or structures that are temporarily there. That definition could be very subjective and somewhat difficult for us to understand, not only to enforce, but also to abide by this RSA when we're conducting UAS operations for public safety entrances. There's another part in that paragraph that talks about gaining written consent from property owners. Again, a lot of the work that we do regarding public safety is rapidly evolving, fast-paced scenarios. We may not always have the opportunity to gain written consent from property owners, given the situation. And then the second point is down on page 2, lines 1 through 11. You'll see that the bill outlines some exemptions for law enforcement, which are good to see. However, some of the exemptions may not, I guess, fit fit the way we do our business quite correctly. So for instance, there's an exemption in there for searching for specifically identifiable missing people. We do often search for missing people, but quite often we don't know immediately their specific identity. So that may be an issue regarding the exemption on this. And if you look further down, there is an exemption, which I think is meant to be a catch-all for law enforcement operations. It says that, there's an exemption for other law enforcement duties, which I, again, think is supposed to be a catch-all in this context. However, the vagueness of that might pose some legal challenges down the road as well. The other issues I want to raise regarding public safety, and having this conversation with Senator Reardon, these may be alleviated if I do some more research into the exemptions, but we want to make sure these drones are able to use for other public safety purposes beyond law enforcement, firefighting operations, search and rescue operations. We have a number of private or semi-private organizations in the state that assist fish and game with finding lost or missing people. We want to make sure that they would have some kind of exemption from this as well. Also, disaster response or emergency management situations. Think of things happening after a large storm or something like that. We want to be able to go out there and survey property to make sure that those disasters could be mitigated appropriately. So, given that, those are the points that I wanted to bring up to the committee. The number of exceptions to the current legislation may also pose a challenge as far as enforcement goes. I know that had been brought up as well. Would be charged obviously with enforcing this potentially, and with a number of exceptions, you can just imagine how difficult that may become for us to actually enforce. So with that, I'd be happy to take any questions from the committee, and I'll try to answer them as best as I can.
Thank you. Questions for this witness? Yes, Representative Horton.
Well, this is kind of a small thing, but you're talking about lines 2, pages 1 to 11. So on 5 to 7, there's a provision about a high risk of a terror attack, and of course, you probably have issues with the phrase specific individual organization. But then the other part, the Secretary of Homeland Security. So what if there's it seems to me hypothetically you could have a terrorist attack, but you don't have any credible intelligence from the Secretary of DHS. So if you have any concerns about that other part of that bullet point C?
Yes, I would agree that could potentially be a concern as well. Thank you.
Other questions? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Tricia Lambert, please.
Good morning, Mr. Chairman and members of the committee. Thank you for allowing me to provide this, to speak for this hearing. My name is Tricia Lambert, and I'm the administrator for the Bureau of Aeronautics with the New Hampshire Department of Transportation. Our role is actually the regulatory agency for all things aviation under the Aeronautics Act, which is RSA 422, which is mentioned in the beginning of this bill for the definitions. We do have drone units in our office that we use to evaluate and to survey the infrastructure for the department, which is roads, bridges, rail, airports. So we do have that. I do have with me the lead of our drone pilot, Jason Levitt, and he's sitting behind me in case there's any questions for him. I guess a lot of talk about preemption. I guess I will leave a lot of the privacy to Trooper Ball and the state police, because they are the ones that have to do this. So there's a little bit of a split here. I'm going to talk only about the aviation side. The federal preemption, and we've had lots of discussions back and forth with FAA. I am aware of the Newton case. If you can imagine, if you start patchworking who has the right to fly a drone in certain areas, and I think that was the point of that case, was if you can't fly through Newton, Massachusetts, how are these people going to know that? And it basically takes away the right to fly freely through that airspace, which I believe is why the FAA, federal government, reserves that right. They call it, we don't want to patchwork aviation airspace, so that you have to figure out where you can fly and where you can't fly. I do believe this is preemption. And as the regulatory agency from the airplane side, I'm not sure how we would regulate that. Just a couple of housekeeping pieces with the bill. If it's directed towards pilots and how they use their aircraft, which is a federal aircraft that's registered with the federal government, they wouldn't know, because they look under our statute, which is 422, which is not crossed over, other than the definitions on what they're expected to do. So that's just a housekeeping issue. Just keep in mind too, the FAA keeps a database on all pilots that fly. Some of them are minors. I think it was mentioned a little bit, touched on when you talk about recreational, because there's a whole group of people that fly, which they call under a trust certificate, which are going to be recreational, and some of them are minors. So just to keep that in mind. I guess the DOT, as I mentioned, we do fly drones, and there is not an exemption for us. And we survey a large portion of the property in the state, being probably, I think, the largest landowner for the state. Just to keep that in mind as well, we would probably need that. We do not survey people, we survey infrastructure. So I guess with that, I will leave it open to questions if I can help answer any.
All right, questions for this witness? Representative Turk.
Yeah, thanks, and thanks for taking the question. So, and that was very informative I appreciate that. So the bill, the way I read it, has two sort of enforcement components. One is about, and we talked about this in the earlier um, violations because you flew over something, because you physically intruded over someone's private property, versus the second part, which is violations based on what you did with the information that you might have gathered while you were doing that. Is it really the first part that your concern is about?
Yes, that is, that would be in our jurisdiction part. As far as what you collect with information and whether the legislature makes that illegal, that would be certainly outside of what we do. Yes, number one, yeah.
All right, other questions? Yes, Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. Would you repeat when the FAA regulates? You said it very fast and I
Sorry.
didn't catch it. I think there were two aspects to it.
Just can you re-ask the question? I apologize.
It was something about, I can't recall it, which is why I'm asking
That's
you.
okay.
But it had something to do with maybe the size of aircraft or.
Oh, so the FAA regulates the airspace. I think we've spoke about that. They also they're responsible for all aircraft, and drones, by definition, are aircraft. And that's why there was a definition in our statute that parallels to whatever they're calling it, because there's different types of drones. There's small drones, so there's definitions for those. So they regulate those. They also regulate the pilot of aircraft, whether it's a helicopter. They are the regulator of that. So they regulate those three things, or they do a lot of other things, but that's their three main components. So that's why the pilot needs to know that they can't fly in certain airspace. And there is federal restricted airspace, but the state to date, we have not, in my knowledge, have been able to restrict airspace without their approval.
Other questions? Yeah.
So what is it from your perspective? What is it that this bill would regulate?
It's the piece of where you can't fly over somebody's property, because that is airspace that is not the FAA, the federal government claims to have jurisdiction.
Other questions? Seeing none, thank you very much.
Oh, is there one?
I'm sorry, was there another question? Oh, I'm sorry, Representative Tripp, sorry.
Thank you, Mr. Chair. Thank you for taking my question. It seems that someone previously had mentioned that there was a limit of 400 feet. Now, if you're over 400 feet, would this bill be applicable?
Over 400 feet for the drone, and I'm not sure if there's exemptions to that, per the FAA's knowledge, would be a violation of the federal regulation. So
That answers my question.
it would be airspace is airspace has like blocks. So there are certain airplanes that fly in those blocks. So if you're obviously your jets are higher up, and FAA is in control of all of that. On who is going to fly where, and they set up a 400-foot ceiling for drones.
Other
Okay,
questions?
so it'd be applicable only under 400 feet, 400 feet and under.
Yes, unless there's a drone. There are larger drones that fly higher, military, those types of things. But yeah, I mean, I can't answer. I don't know if I can answer that question because I can't relate it back to the bill.
Okay.
But it would be if you're a regular flyer of a drone or a UAS and you violate that 400 feet, that would be a federal regulation violation.
Right.
How it applies to this, I'm not sure I can answer that.
Well, thank you.
All right, other questions? Representative Birch.
Thank you. Just a quick question to clarify this last conversation. I understand that the FAA tries to keep jets up here, commercial planes perhaps here, drones here, and 400 feet. You're not saying that the FAA doesn't regulate under 400 feet. They own all the space. Is that right?
That is my understanding, yes.
Thank you.
All right, other questions? Representative Manos.
Thank you, Mr. Chair. I found what I was asking you about earlier. Under your statute 422:3, aircraft means a device that's used or intended to be used for flight in the air and for which a federal registration certificate and number have been assigned.
Correct.
That's what I was confused
I
about. Could
apologize.
you just explain that and how that applies with drones?
So our statute basically follows if there is a federal ID to that aircraft, and there are on drones, they're required to register over half a pound. So there are smaller drones that you buy, maybe at Rite Aid or wherever, and they don't need to be registered. We don't typically spend a lot of time with them. And so if it's got that federal identification number, on regular aircraft, they call it an N number, then that falls into the FAA's jurisdiction. It is in their database as being recognized as an aircraft. Is that what you were looking for, or shall I expand?
I believe so. So the kind of drones that you buy at Rite Aid would not fall under this bill.
If it's under a half a pound.
Thank you.
All right, other questions? Seeing none, thank you very much.
Thank you.
All right, is there anyone else who wishes to be heard on SB 519? Seeing none, I'm going to close the hearing on SB 519, and I'm now going to open the hearing on SB 619. And the chair recognizes Representative Mann.
Thank you, Mr. Chair, members of the committee. For the record, Representative Dennis Mannion, I represent Rockingham 25 Salem, and I was just asked to introduce this bill on behalf of Senator Abbas. I'm not a co-sponsor of it. My first time seeing it is right now, but this bill establishes procedures for expedited court hearings and disposition of animal confiscated due to allegations of animal cruelty. Looks like there's some language that's been added to 644.8 that assists with the disposition of animals, obviously for safety reasons, well-being of the animal, and health of the animal. So it adds three sections to it.
All right. Thank you very much,
Thank you.
Representative.
You have a question?
I didn't know.
I won't be able to answer it, but I figured you might have one. Thank you.
All right, next I'm going to call on Patricia Morris, please.
Thank you, Mr. Chair. Good morning, committee. Thank you for having me here today. My name is Patricia Morris, and I am here in two capacities. My first capacity is as a member of the Governor's Commission on the Humane Treatment of Animals. This consists of about 25 organizations with a representative that are appointed by our governor. It includes police chiefs, sheriffs, Senator Waters, Representative Comtois. It has the state veterinarians, a bunch of us. We reviewed Senate Bill 619 as amended and have unanimously voted in support of this bill. So I wanted to get that on the record. And then secondly, myself, I have been practicing animal law in New Hampshire for 20 years now, and I have taught it for 15 years at the University of New Hampshire School of Law. I have a working horse farm in Barnstead, New Hampshire, and I have been involved in countless animal cruelty cases, from the initial investigation to warrants to hearings and motions and trials. So I actually have worked alongside Senator Abbas with this from the initial introduction, along with Chief David Suckling from the Alexandria Police Department, and that we have gone through a significant amendment. I also urge the committee to please support this bill, and I can give you a little background fairly quickly. When we would go before a court, right now the current cruelty statute states that animals are on what's called a rocket docket, meaning that upon confiscation of someone's animals for cruelty, there has to be a hearing in front of the court within 14 days. That's all it says. Usually, if you have a court hearing, there is a title. There might be an arraignment or a motion for bail reconsideration or a motion to strike or something like that. This gave the courts no authority, no scope of what that 14-day period was going to do. So when we would go before a court within that 14 days, they did not know what we were there for and what they had the powers to do. So Senator Abbas introduced this as a way to say to the courts and to both parties, the defense and the prosecution, here's what can happen during this time. And in this bill, it specifically states it can also include an arraignment. But animal cruelty seizures are very different than seizing evidence in another crime. If I seize your car or I seize your ammunition or your drugs, those go to a secure location and can be held. Animals can't. They have to be cared for and treated, and it's an exceptionally high cost. Chief Suckling's latest case with some goats and sheep up in Alexandria, over $150,000 of cost of care just holding those animals during the legal proceedings. So one of the things that this would allow the court to do, both parties, is to talk about what are we going to do with the custody of the animals? Is there necessary, mandatory veterinary care that has to happen right now? And those are the types of things that this looks at. And then finally, it also allows for a bond, which is already in the statute, current animal cruelty statute. And finally, it states that if the defendant or the accused does not appear for this 14-day hearing without giving the court notice of exigent circumstances within 3 days, then the court can still go ahead and make a ruling. What we were finding is that the accused were not showing up, and then the animals were again left being held, or we had no idea what we were going to do going forward. And just to remind you that when animals are seized, if the accused is convicted, they will be responsible for those costs of care. But if they are not convicted, either there's a plea or they are found not guilty, that burden of cost of care lies on the towns and the town's taxpayers. So it is very important that we get in front of the court and the court understand what we can discuss and what their powers are. So thank you, and I'm happy to take any questions you may have.
Questions for this witness? Representative Birch.
Thank you, and appreciate your experience in this matter. If I am correct, and correct me if I'm wrong, that at this hearing, which can be in 2 days, 4 days, 5 days, up to 14 days, possible extension, and the court determines that somebody has to put up, or the owner has to put up a bond. And if the individual does not, let's say, is unable to post a bond, one of the consequences that may happen is that the animal or animals is forfeited. Is that correct?
That is correct. It is a permissive, the court may issue a bond in up to $1,000 per animal, and that it may also waive that. There'll probably be a hearing on it to determine need and whatnot. You are correct, Senator, Representative.
I don't think it says may, I think it says shall. The animals shall be, if such bond or security is not paid within 30 days, the animals shall be forfeited.
Right, you're right. I stand corrected. It should be, it is permissive for the bond that they may issue, may require the defendant to post the bond, but yes, then it could be, it is shall as far as forfeit is concerned.
So, given your legal background, I'm going to ask you a kind of a compound question about this kind of hearing, which happens awfully quick. It's only focused on the legality of the seizure, not the culpability. And the forfeiture is based not on guilt or innocence of the owner, but simply whether a person can put up cash within the specified period of time or they lose their animal or animals. So my question to you is, how does that comport with due process concerns under Part 1, Article 15 of the New Hampshire Constitution, as well as property protections under Article 1, Part 1, Article 12, and whether requiring a bond prior to finding any guilt without any determination of culpability, and which could be potentially serious amount of money if you've got a dozen chickens or something like that, how that comports with proportionality under Part 1, Article 18. And I think I could go on. But the whole idea of, can you talk about the idea of taking away somebody's property without any adjudication as to whether the person is culpable or not, under our Constitution or under the federal Constitution?
And that's an excellent question, and I can answer that easily, which is you're absolutely correct. It does do violation of due process because it is not based on the culpability of the client. It's based upon the warrant, right? The probable cause, the search, the seizure. So I would want to see this part stricken. That was an oversight. But you're absolutely correct, Representative.
Could I just clarify which part you're talking about? You're talking about the forfeiture part?
I believe, so there's already a bond section within 644.8, which is our cruelty law. And that is upon when there's going to be an appeal, right? And that's up to 2,000 per animal, but there's already been a determination there. There's already been rulings. It's an appeal. So I would think that the forfeiture needs, I don't think the bond or the forfeiture would need to be in there, period. But if the bond stays there, we want to bond that early, it would have to be completely permissive on the behalf of the court. But again, I agree with you that absent any finding of the culpability of the accused, putting up a bond at that point in time is going to be problematic.
Thank you. You just avoided a long conversation about how this meshes with our forfeiture law,
Correct.
which requires a finding of guilt before property can be forfeited. So,
Correct.
thank you for that.
Any other questions? Yes, Representative Tur.
Yeah, thanks, and thanks for taking the question. I don't know how this fits exactly. I know last year there was a lot of discussion around what I guess was called the Lee goat case, where there was a lot of animals taking questions about whose responsibility it ultimately was and whether that was okay. In this bill, does it address sort of, aside from the bond question, who ultimately is responsible for the cost of caring for those animals? I know there was a question around the SPCA being potentially the best placement for certain animals, and then does this still allow the liability, I guess I'll call it, for caring for those animals to go to whoever the best placement organization is?
I don't think this specific bill, Senate Bill 619, does address that.
Okay.
There are other bills coming your way that have come through here that talk about as far as custody during this period of time. But it is my understanding from my experience that if the state law enforcement seizes the animals, it is their responsibility for cost of care if the defendant is found not guilty. Generally, because there are humane organizations throughout the state, they will tend to absorb those costs and then eventually adopt out the animals. But that it just depends on if there's a surrender and then the plea negotiations can go in there. But I was involved in a major horse case in Candia. There was 27 horses involved, over $60,000. And the town of Candia had to forego 2 police cruisers and some other things in order to cover that cost because the SPCA did not cover it in that case.
Other questions? Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. I wanted to ask you about page 1, lines 7 and 8. The purpose of the hearing shall be to determine whether the confiscation of the animal or animals was legal. And I didn't understand what that was referring to, what the standard would be, who has the burden of proof. Thank you.
So that returns back to the due process of taking someone's property and whether or not, with animal cruelty, the probable cause is if you don't have a search warrant, it has to be for exigent circumstances of the life or the health of the animal. So if I went to and I seized animals, I did not have a search warrant, but I seized them without it, and I said this is based upon, I believe that the animal is in, their health is, or life is in imminent danger. This would be the time where the defendant could say, hey, we want you to prove this, we want you to do that. So the burden's always going to be on the state to prove it beyond a reasonable doubt. But this gives the defendant that time early on to come up and say, these were seized without a search warrant, or I'm going to challenge the validity or the execution of the search warrant. It also gives them a chance to say, I'm also not an owner. So it's that type of, to really look at the due process and make sure that the due process of taking someone's property was done correctly, legally.
Representative Scully.
Thank you, Mr. Chair, and thank you for being here to help us understand this better. So page 1, line 3, court shall give cases in which the animal has been confiscated by an arresting officer priority in the court calendar. Are there situations where animals are confiscated without arrest? And do we need to deal with that issue?
So the lines 3 through 6 are currently in 644-8 now. But yes, especially if an owner is not home, or the caretaker, because it may not be the owner, it may be the caretaker, is not home and the animals are seized, then they will be seized and taken. And so there may not be an arrest at that point in time because the animals have been seized. There was no one on the property. We do see that abandonment issue at times, or someone may be at work when a search warrant is actually executed.
May I follow up,
Yes.
please?
Yep.
Thank you. Well, given that that is the case, would this almost be a loophole where the animals, would we want to give the same consideration for having the issue dealt with by a court in those situations if an arrest did not occur?
I guess I'm confused with the question. This would, I mean, whether the owner was, there would have to be charges brought. The animals just can't stay. So the animals might be seized this afternoon, pursuant to a search warrant, but there's going to be an arrest warrant out for somebody, or there's going to be a bench warrant out for that once they determine who should be in care, possession, or owner.
Right. All right, so to my understanding then, if the animals are confiscated, there will automatically be an arrest associated with that.
Generally, yes.
All right, thank you.
Other questions? Seeing none, thank you very much.
Thank you all.
Is there anyone else who wishes to be heard on SB 619? Seeing none, I'm going to close the hearing on SB 619, and I'm going to open the hearing on SB 552. And I thought I saw Senator Avard here. Oh. Yeah, oh yeah, would you mind? Thanks, Dan.
I can
Oh. Oh, I saw him there a minute ago. Oh, great. Thank you. Senator Avard.
Timing is everything, right?
All right, Chair recognizes Senator Avard. Thanks.
Do I need to give you this?
Yeah. Well, you can give it to me when you're done testifying.
All right.
That's fine. Thanks.
Story of my life. All right, I assume I'm ready to go?
Yep,
Thank
please.
you very much. Thank you, Mr. Chair. Thank you, Chairman and members of the committee. My name is Kevin Avard, State Senator for District 12. I'm here today to present 552, a Senate bill. And today I'm here as a dad. I'm as a grandfather of 4 granddaughters. And like a lot of parents, I think about my daughters and their privacy, their safety, the opportunities they have growing up here in New Hampshire. This bill is about making sure that in places where privacy matters, like bathrooms, locker rooms, that we all use in common sense rules to protect women in privacy and safety, as well as in athletic settings. When it comes to sports, this is about fairness and safety. And on average, we all know that biological males are bigger, faster, and stronger than biological females, and that's just a reality. And when the line gets blurred, it's the girls who lose out, whether they're playing time on a field or scholarships, or even losing a spot on the team because they were replaced by biological males. These aren't abstract concerns, and I hear about them directly from parents in my district. I remember a news story a few years back about a woman in high school playing at a basketball tournament where there was a bearded biological male athlete competing with as a trans woman. The news story said that several girls were injured during the tournament because they were treated like ragdoll by this player. One of the coach forfeited the game instead of playing out of fear that the players might be injured. I've also heard from business owners who are just looking for clear guidance. Right now, the law isn't clear, and people are worried about doing the right thing and still ending up exposed with legal risks. I also think it's important to look where things are standing right now with the Title 2024 Title IX rules, which were recently vacated by a federal court, if I'm correct. And that means that we're back to the 2020 rules. And those rules take a different approach. They don't include gender identity in the definition of sex. Instead, it focuses on biological sex. This shift matters. In fact, this past summer, a group called Defending Education filed a complaint with the Federal Office for Civil Rights on behalf of New Hampshire parents over this exact kind of policy. And as far as I know, they're still unresolved. But it is something that I would encourage this committee to look at because the complaint, and I have a copy of the complaint here. I only have 2 copies. I don't have 20. So if you want to.
All right, now, if you give it to us, we'll get copies.
That's a copy. But it's something to consider. At the end of the day, the compliance with the federal law is an optional. And if we get this wrong, there's a real risk to federal education funding. And that's not something I think we can afford to ignore. In fairness, this bill is also about safety. I'm from Nashua. And in my own community, we saw a former state representative, Democrat Stacy Lawton, convicted and sent to prison for taking pictures of children in private areas of a children's facility. This individual had access to the bathrooms while he was a state representative. We have 4th and 5th grade girls that attend this building, and they use those bathrooms frequently. I don't care if he's a Democrat or a Republican, independent. I don't care if he's a monkey. It doesn't matter. The safety of these children matters. Mental illness is gender identity, gender dysphoria is still listed as a mental illness. I go to the gym and I talk with people in the public, and they come up to me as I'm lifting my weights or I'm on a treadmill. And there's a lady at the gym. She seems to be the mayor of the gym. She talks to everybody, and there's no sign that says I'm a Democrat, Republican, Independent, or anything else. I saw her having a conversation one day with another lady, and they always come up to me and they ask me questions, and so we were on the conversation, and then I just said out of the blue, "How would you feel if I walked into your bathroom right now?" They both said emphatically no with expletives. One of them happened to have been in the mental illness field for about 30 years. She was a counselor, therapist. And I said, okay, well, what if I had mental illness? Now, this lady told me emphatically with an F-bomb, I would tell you to get the F out of the bathroom. And then, as clear as that compassion, as that conviction was, I said, well, what if I had a mental illness? Her entire expression changed. And she was like into real reconsideration. It's like, well, and that spoke to me very loudly. But then I followed up with, what if that person had evil intent? Can you, as a professional, tell the difference? And as quickly as she told me emphatically, get the F out, she said, no, I cannot ever tell the difference. So, what does this bill do? It basically helps set guidelines. It isn't a mandate. Um, just to reiterate what it does, it focuses on protecting women and young women in personal private spaces, such as bathrooms, locker rooms, where privacy and physical safety matter. In schools, SB 552 promotes fairness and safety by allowing the schools to consider the physical advantages of biological males, generally having the strength and size and speed. SB 552 is a middle ground bill. It creates no mandates. I got to repeat that. This isn't a mandate. It creates no mandates and requires no policy changes. It simply gives an organization the option to separate certain private spaces by biological sex. This reflects concerns raised by parents, business owners, religious leaders seeking clarity and certainty under current law. SB 552 does not weaken or roll back New Hampshire's anti-discrimination laws. All existing protections still remain in fully intact. Its purpose is to clarify and local control, allowing schools, businesses to make decisions they believe best for their students and for their customers. What it does not do, it does not mandate sex separation bathrooms, locker rooms, sports teams. It does not force schools, businesses, organizations, or change existing policies. It does not remove gender identity or protected class from the state law. It does not authorize harassment, exclusion, or blanket discrimination. It does not interfere with single-user or family restroom options. Final point, again, Title IX, talking points, and that's what I have in bold letters here. It says that no person can be discriminated against based on sex in any education program or activity. This includes sports, athletic facilities, locker rooms, admissions, academics, employment, and education, or any other items. I know we've seen this bill before, and my constituents have come to me and brought up what is going on with this bill. I know it's had a history, but here we are again, and I have to listen to them. And I agree with them. Again, we're not trying to mandate, we're just trying to make some clarity. I just went to the bathroom just now, and I saw an individual look at both signs. The individual was the opposite sex with me and went into the ladies' room, and I went into the men's room. I was okay with that. I'm sure she was too. And I don't know, maybe you can do your research, but right now, I don't even think there's a bill that if I wanted to walk into a ladies' room, I don't know if there's a law against that. Isn't that interesting? How have we enforced that over the years? Well, we didn't, but people still respect privacy. And with that, I will take questions.
Question for Representative Smith.
Thank you, Mr. Chairman. Thank you, Senator, for bringing to us the 6th or the 8th or the 10th bill on this very subject, and you acknowledge that. I want to ask you, I've been thinking a lot about these bills because they keep on coming up. What would you think if we looked at it in a slightly different way? And if we suggested that facilities have one bathroom, private bathroom, that would be available to any heterosexual person, male or female, who for any reason felt uncomfortable going into the other bathroom or locker facilities that building offered.
I think a lot of places do that already, to be honest with you. At my church, we have 5 or 6 different bathrooms, single stall bathrooms, separate doors. And on the other side, one for male, one for female. A lot of places are doing that. I see that in a lot of gas stations, but that doesn't solve our problem. And it could be a major expense for some organizations, maybe not for others, but that's why everybody's looking for clarity. Some facilities can't do that. They're not financially able to do that. And I think this bill basically adds a little bit more clarity. But I think other people are already, I see it everywhere, single stall bathrooms. You can go to a hospital, single stall bathrooms. So it is already being practiced in a lot of areas right now.
Other questions? Yes, Representative Horrigan, then Representative Tripp.
Thank you very much. First of all, you talk about the issue of whether there's a law against going into the opposite sex bathroom. I believe there isn't a law specifically, but there's plenty of laws about harassing or assaulting people in bathrooms. But the reason I raised my hand, you mentioned Representative Lawton, and I served with her. I guess she considered me a friend. It was sort of horrific crime that she committed, but would you believe there's at least one other former member of the House who was convicted of a sex-related crime, although I think he took a plea bargain, so like he didn't have to be in the sex offenders registry. And also there's a current member who's innocent until proven guilty, but who's being tried for I guess a sex-related crime.
Is there a question?
Yes, so those people were both cis males, so are we worrying about, and I hate to say this because I'm a cis male, and I assume you are too, that are we possibly worrying just about one group of people and not worrying about another one that's more likely to do these sorts of things?
Thank you for the question, Representative. I don't know what a cis male is, to be honest with you. However, my major concern is, the bathrooms, when 4th and 5th grade girls are there. I don't think you could tell whether somebody is suffering from mental illness or has evil intent. And whether you're cis male or whatever it is, that bathroom really should, there should be the ability for an institution to make policy that says biological, male or female. And please keep in mind, this Title IX isn't going away. This is a serious issue, and there could be some serious federal monies that may be at risk. I don't know, but you can do your investigation. This is your bailiwick. I'm not a lawyer, but it is a concern. Unless you had a question too.
Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question. It's interesting the way this bill is structured, in that it gives municipalities and other organizations the opportunity to form their own policies on this. It seems that this is kind of a way of getting this problem into the courts so that the courts can have a swing at this, because in my opinion,
Sure.
Yes.
I assume, Representative Tripp, there's a question in here.
There is. Would you believe?
Come on, give me some better than that.
All right. But, this seems to be, who's the bigger victim, in this? Is it the transgender people or the biological women? Is this the intent of the bill?
The intent of the bill is to add clarity, definitely to consider the Title IX. Protection of the young biological females. That was part of my opening statements. Like I said, I have 4 granddaughters. I might have a great grandchild very soon. Don't know. A lot of coffee. So, and it isn't picking winners or losers, and we can let the courts settle on that, I guess. But I think when my constituents come to me and they say this is a concern, this isn't me just pulling this out of a hat. We're talking from a wide spectrum. I'm going to be frank with you. I've had certain Democrats come and whisper in my ear, "Thank you for doing this," and they're afraid to speak up because they don't want to be labeled like I hate this person, or I'm against this group of people. But they have concerns, and I respect that. And we have concerns on maybe in the legislative body because, like you said, it keeps coming up over and over again. Well, why? Because it's a concern. The problem isn't solved. Just because we don't win on the day doesn't mean the problem goes away. So I need your help. I need your help.
Question,
Thank you.
Representative Birch, then Representative Rombo, then Representative Tur.
I want to ask you about a couple of things, but since you've emphasized Title IX, let me ask you about that. Understanding that the U.S. Supreme Court has declined so far all emergency requests to enforce bathroom bans. So you go to the next level, and I assume you understand that the Fourth Circuit Federal Court of Appeals and the Seventh Circuit Court of Appeals have both thrown out these kind of laws. So yes, the 11th Circuit has gone the other way, so it's fair to say split in the circuits. But would you agree that there is no, and the First Circuit, which we are, which has a very expansive view of equal protection, has not ruled on that? Do you agree with all of this so far?
Well, I agree that what your statements may be very true, but I also agree that if and you would understand this better because I believe you're all lawyers, or at least most of you. You might, some are, but that if the 2024 Title IX has been vacated, then it reverts back to the 2020. I could be wrong, but if that's the case, then it's the old rules that apply, not the new rules.
Right, but we're not, you're raising a hypothetical, I assume.
No.
So if I could switch on then to the statement you made about sports, that men are bigger, stronger, and faster. I think
Generally.
as why you think there should be separation. I don't know if you were old enough to remember the Negro Leagues in baseball, where people of color, baseball players of color, were deemed faster, bigger, stronger, and faster, and therefore should not compete with white baseball players until 1949, 1950, when Jackie Robinson and I think Satchel Paige, Roy Campanella, and others joined white baseball players. The sky did not fall in. They competed.
So is there a question here, Representative
Yeah,
Birch?
I will wind it up to. I've had, Mr. Chair, I've listened to, as we say, 7 or 8 of these, and I don't know how many hours of this, roughly the same bills and the same testimony, and I do have some questions. My question is, if the sky didn't fall in and Willie Mays could play fine with Mickey Mantle, and all of the fears that were talked about why people of color couldn't play baseball with white people, why are you assuming this is something different?
Yeah, I don't think there's a moral equivalence on any level with this. I guarantee that Mickey Mantle and all the others used the bathroom that was appropriate for their gender or for their sex. And I would submit that they didn't go into the ladies' room.
I was talking about the sports part.
I know you are, but I don't think there's a
So
moral
you don't have
equivalence.
an answer for that?
Yeah, my answer is
Thank
that there isn't a moral equivalence to that.
Next question, Representative Rombo.
Thank you, Mr. Chair. Thank you for taking my question. I would like to ask about the practical implications, the enforcement here. You related a story of a constituent who said if you walked into the bathroom, she would tell you to get the F out. There are individuals who have transitioned from female at birth to male who look like you. Is your testimony that that person should be using the women's bathroom?
My testimony is that the place where, the facility that adopts a biological sex policy, well, that'll have to be their problem.
But if that policy were adopted, someone who looks like you would be in the bathroom with the 4th and 5th grade students at the State House who you're concerned about?
My concern about it is the safety of those little girls, yes.
And
You can't tell me that somebody who's transitioned isn't suffering from mental illness. And there's no way you or any other person can tell me that that gender identity isn't a mental illness, or if there is a perverted sense of wickedness that lays in their heart. You cannot tell me that. But it reduces the risk. And so individuals that choose to change their identity, this bill doesn't stop them from doing that.
may I have one follow-up question, Mr. Chair?
Follow-up?
How do you anticipate this bill being enforced with regard to the bathrooms?
That would have to be up to the institution.
Can you tell me any scenario where you can see how this bill would be enforced by a given institution?
Once it passes, maybe.
Representative Turk.
Thanks, and thanks for taking the question. And it's along similar lines, and I guess, you know, in the previous iterations of this bill, along the way, there's been a lot of discussion around the fact that this bill does not define biological sex, other than just defining biological sex as biological sex. And I don't want to go down that rabbit hole today.
I think we've done this before.
We have. I guess my question is, in your opinion, can biological sex change after birth? Can it change, or is the sex at birth definitive?
I definitely believe it is definitive.
Can I ask a follow-up question?
Sure.
Do you also acknowledge or agree that there are legal medical procedures in the state of New Hampshire that could result in somebody born, say as a female, based on your definition, to have the musculature that I think you're concerned about in sports, or to have the physical characteristics, you know, body hair and stature that you maybe are concerned about in bathrooms, and that essentially this would still permit that to be the case. You could still have that person with the greater musculature through legal medical intervention playing on essentially a girl's team, as has happened in other states where this law has been enacted, or similar laws have been enacted.
Thank you, Representative. I don't think this bill talks about that distinction. It doesn't distinguish on that level to period. It doesn't distinguish that. This bill is basically about protecting individuals, whether in sports. It also does define about, I believe, ladies in prisons as well.
Right. Other questions? Yes, Representative Perez.
Thank you. Thanks for taking. I have a statement, and it's one statement. Thank you very much.
You're very welcome.
Any other questions? Sure, go ahead.
Thank you, and thank you for listening to another perhaps longer question. The preliminary part is, do you know whether I am transgender or whether Representative Rombo is transgender?
I don't know how that applies to this bill, Representative.
I'll do that in follow-up.
I'm not going to turn this into a debate. So if you have a question, ask the question, okay?
My question is, if after this hearing, I go into the men's room, Representative Rombo goes into the ladies' room, we do our business, we wash our hands, and we leave. How does anybody enforce this bill?
You know, I keep hearing that over and over and over again. And I think it's a nice way to avoid voting one way or another for this bill. I think we for years have all kinds of laws, whether it's a speeding law, how do you enforce it? Well, you see people speed at all? I do. How do you enforce it? Well, there happens to be a situation maybe that we get caught. Maybe there is an individual that is acting inappropriately. in a bathroom, taking pictures, or making somebody feel uncomfortable, well, that raises the flag. That might be the way it gets enforced. But I do believe if we do not act on this, there may be serious consequences up the road. And I'm going to tell you, whether it's a Democrat or a Republican, if individuals like Stacy Lawton can go into the bathroom when they're 4th and 5th grade girls, and this man has done some very wicked things with his trans partner in a licensed facility, putting those children on display is evil. And it needs to be addressed. And this will come back. If this doesn't happen, it's coming back. Somebody needs to take a strong vote and vote in line with us. It's not a mandate. It's not a mandate, folks. Let's take care of it this time, right? Let's just take care of it and move on. Because I think it's putting people at odds with each other. And I think it's time we come together. I'm begging you to come together on this because it will not go away.
Other questions for this witness? Representative Smith.
Thank you. Just a very quick question. I really thank you very much for the effort that you have put into this and your commitment to the issue. Could you help me? I was under the impression that the former legislator to whom you referred was in fact prosecuted and convicted, so that even without the benefit of your well thought out proposal, the existing law in New Hampshire had the power and took the steps to hold that person accountable. Am I wrong about that?
I'm grateful for that question, and I'm not wrong about the fact that this individual also had access to the bathrooms prior to him being caught in the ladies' room when there were little children in there.
Thank you.
Right. Other questions? Yes, Representative Ball.
Thank you, Chair. And Lynn, perhaps you can help me understand something as a woman. And believe it or not, I was in high school in 1972 when Title IX was passed. And so I'm looking at this as my life experience of seeing women achieve something in getting rights, and now they're getting chipped away and we're losing them again. My question is, and I know the answer, but I'm going to ask it anyways. Is there a law in New Hampshire for indecent exposure?
I don't know.
There is. I believe it's law. It's 645 that a man cannot expose himself in a way that would affront another person or a woman. So what I have been trying to deal with or understand is how is it okay for genitals to be shown to me or against the law to be whipped out outside in the hallway, but we can walk into a ladies' room or in a locker room and those same genitals can be shown to me and I have nothing I can do about it because they identify as a woman. I'm just wondering, how do we square that? If you could help me understand that, because that's the confusion I have been dealing with for all of these years as this is progressing.
Well, I think we passed this bill, number one. And I think, when I go to the gym, I haven't been in the ladies' locker room, but I know in my gym, there's showers, there's locker room, and the bathroom, and all in an open concept. And so sometimes if you walk into the men's locker room, it's not a pretty sight. So I would assume that the ladies' room is just the same way. And I do believe that individuals that take advantage of the situation right now can make women feel uncomfortable. And right now, I don't see a solution other than adding something like this. So,
Other questions? Yes, Representative Horrigan.
Not to belabor Representative Loudon's course case, I've actually looked at a lot of the federal court files, which are available through PACER. So I'm not sure if that's exactly the crime, which crime the crime's committed, but crimes were horrific. She's pleaded guilty. She's going to be in prison for a very long time. And I'm glad. And by the way, I believe it's in a federal men's prison. But
There is,
but even if
the question is,
this law somehow prevented her, still from going into the ladies' room. What's to stop her from going into the boys' room or the men's room and then doing the same thing to young men or little boys or old men, as the case may be? So what's this? How does this bill like solve that problem, or does it?
Well, number one, it takes the risk out of the ladies' room, doesn't it?
All right, but you follow up, but you don't. But I guess you do understand these things happen. Men do these things to other men and boys in men's rooms too. Anyways, aside from whatever's happening in the ladies' room.
Well, I think men know how to enforce the law.
all right, other, Representative Tur.
Thanks for taking the question. I just wanted to follow up on the statement which you mentioned, which has been said a lot, that that this isn't a mandate. And I guess my question is this is a modification to what's titled the Law Against Discrimination. And I guess I'm wondering, do you need to mandate that someone has the ability to make a potentially discriminatory judgment, or does simply allowing someone the option of making a potentially discriminatory judgment invalidate the whole concept of prohibiting discrimination on that basis?
Well, the premise of your question is that they're discriminating I don't know, maybe arbitrarily, I don't know. However, if an institution wants to mandate biological sex or biological male and female, this bill protects them from liability of discrimination. If it takes that essence out. So if you're a biological male and you go into a biological male bathroom, everything's great. But if you go into a female's bathroom, well, now you're going to have consequences, especially if somebody complains about it. So it may happen just like speeding. You might speed or you might drive drunk a half a dozen times. But there's going to be that one time where you do it and you get caught. And it could be the fact that you've made an individual uncomfortable to where it starts a red flag. For instance, well, we have a second floor, and there is an individual on staff who is, maybe she's 5 feet tall, thin as a rail, went into the bathroom. A 6 foot tall male figure with a beard was in the bathroom. She felt intimidated. Doesn't matter how he's dressed. She left the bathroom until he left. Nothing she could do about it. So are her rights not as important? That's what we're pushing. That's what's been pushed. And it's got to stop. I'm pleading with you. It's got to stop.
All right,
That's why we're putting in this bill.
Other questions for this witness? Seeing none, thank you very much.
Committee, thank you very much, and I appreciate the questions.
So I have a number of other witnesses. With regard to all of the other witnesses, because of time constraints, and frankly, because we've, as a number of the representatives have on the committee here have already indicated, we've heard the subject matter of this bill many times. So I'm going to impose a 2-minute time limit on all other witnesses. So next, I'm going to recognize Representative Catherine Prudhomme O'Brien, please.
Thank you. I have a lot to say on this. Well, first of all, I'll introduce myself. I'm Catherine Prudhomme O'Brien. I'm in my 5th term representing Derry. I think that one of the things we should think about when we address this issue is why were individual facilities created for men and for women in terms of bathrooms, jails, sports? Why was that created in the first place? And were the people that did that, were they wrong? Our ancestors, were they wrong? Were they bigots? Were they transphobes? Was there something wrong with them? I have a lot of adverse experiences. I think what they call them now is ACEs, adverse childhood experiences. When I was 15 years old, 40 years ago, around this time of year, every time just the seasons changing reminds me of, it's very hard for me to talk about. But I'm glad to do it because it was one of the most influential things that happened to me in my entire life. When I was 15 years old, I was placed in foster care in Massachusetts. My social worker was looking for a home for me for a long time. It was really hard to find something for a 15-year-old, for teenagers. I did not have problems with the legal system. I did not have mental health problems. I was an ideal candidate. There still wasn't anything available except a group foster home, which was an emergency placement, and I found myself there. When I arrived, I'll say it quickly, okay. When I arrived, it was all female. And when the woman who ran the foster home told me that the state was encouraging her to take boys in, but she did not want to do it because they hit on the girls in the middle of the night when the girls don't want it. I think you can read between the lines what I'm saying, and you can also make a pretty educated guess about why a lot of females wind up in the foster care system because of sexual abuse, and that's a very common reason.
Right.
I am not finished, sir. I'm not finished.
I'm sorry, Representative. I imposed a 2-minute limit, and the 2-minute limit applies whether you're a representative or not. So respectfully, I'm sorry.
All right. Well, then I will wrap up. When the boys were about to come in, I fled. There is a good reason for why we have these kind of facilities. They should remain male and female. I do have trouble here at the State House.
Thank you, Representative. Next, I'm going to call on Representative Sarah Landers, please. Orrs, please. I'm sorry.
Thank you, Mr. Chairman and committee. I'm Representative Cyril Orrs, representing Merrimack 13, Chichester, Pittsfield. And as the rep in front of me was trying to testify to, I have had many female reps, about 10 or 12, I'm not sure, come to me and looking for help because they've gone into the restrooms in our State House and there's some pervert in there. And let me tell you something. We closed the state mental hospitals and now these people are running around on the streets. It's not often a man gets raped by a woman. Women get raped by men. And anybody that wants to think that this isn't a problem, we got a problem. And I believe the governor would sign off on a bill like this if her daughters ended up in this situation. I'm surprised the women haven't taken care of this problem themselves. I think if a man wants to be a woman, he should be castrated. Let's get it over with. You want to be a woman? Let's get it over with. I mean, think about it. We haven't seen this kind of doctoring, if you want to call it healthcare, since like the 1930s when people took other people's bodies and made lampshades out of them. We got doctors turning men into women, women into men. I mean, it's a circus. You used to have to go to Barnum and Bailey's or whatever and pay $0.25 to see this kind of thing. Now you can go to sections 4 and 5 in the State House and see it. It's ridiculous. I think I'll wrap up right there.
Hang on. I'm sorry.
I'll take questions.
Hang on. 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 Hang on.
Oh, I'm sorry, I meant 3, 4, and 5. I'll take questions.
Questions for this witness? Seeing none, thank you very much, sir.
Thank you very much, I appreciate it.
Next, I'm going to turn to, call on Attorney Ian Hewitt, please.
Mr. Chair and members of the committee, Ian Hewitt for Cornerstone in support of Senate Bill 552. As Representative Smith said, there have been like a dozen of these biological sex separation bills this year. We support this one specifically because we think it's the legally soundest and most well-crafted of all of the biological sex separation bills. I've read almost all, most of the case law in this area from around the country, from certainly circuit courts of appeals and a lot of federal district courts over the last couple of years. And it does matter whether a law like this is well crafted or not. I think a lot of legislators are fatalists about this, and they think all the liberal jurists are going to find you have to use gender identity alone, and then they're just going to kind of layer their jurisprudential reasoning on top of that. And even if that's mostly true, it's not entirely true. We've seen over the past few years a number of judges appointed by Obama or Clinton or Biden who have acknowledged the legitimacy of biological sex separation in published opinions. So it's important to have a well-crafted law, regardless of the politics. And one of the major things that makes this law more well-crafted than other similar bills is it doesn't try to get into a legal code-like definition of biological sex based on birth certificates or genetic characteristics. Having read a lot of cases, I have never seen a law where having an exhaustive definition like that helped a state succeed in its biological sex separation policy. And on the other hand, I've read many, many cases where the attempt to create an exhaustive legal code-like definition of biological sex resulted in bills like this being tangled up in their own web in an unnecessary way that undermined the bill. So this bill takes a more elegant, common sense approach that we think will fare better in the courts. And for that reason, we would ask you to pass this bill.
All right, thank you. Questions for this witness? Representative Perez.
Thank you. Thanks for taking my question. Are you aware, I think it's NYU Hospital in New York City has stopped doing any surgery for biological sex changes, and multiple doctors have come forward stating their profound regret for having doing it?
I'm not aware of that, Representative, but that doesn't surprise me because I think in multiple areas we see kind of a collapse in the elite consensus in this country around gender ideology. And I think you especially see it in the legal arena. You have liberal jurists, like I mentioned, who are increasingly acknowledging the legitimacy of upholding biological sex, and even organizations like the ACLU, who've appeared on many of these bills over the past few years. They now in court make much more moderate arguments than they used to make a few years ago, and I think that's because the consensus is shifting.
Other questions? Yes, Representative Horgan.
Well, I won't get in the ACLU. There is a person from the ACO sitting behind you, may or may not fill out pink cards. My question is, what exactly is the enforcement mechanism? So we're supposed to, it's in the chapter about the Commission on Human Rights. So what exactly does somebody who feels that they're aggrieved because there's biological males, whether in the ladies' room or whatever? So what's the enforcement mechanism if this law gets passed? Like, how does the Commission on Human Rights even deal with these things?
The Commission on Human, thank you, Representative. The Commission on Human Rights has no basis under this bill to initiate any kind of investigation for a reported violation of the language in this bill. There is no enforcement mechanism because this bill is a clarification that certain conduct is not prohibited. So it removes enforcement. It doesn't create any additional enforcement.
All right. Other questions for this witness? Yes, Representative Andrews.
Thank you, Mr. Chair, and thank you for taking my question. I have daughters, and I would do anything to protect them, even today. My question is, then I don't understand, why is it wrong wanting to protect biological females?
Well, I think what we would see, on bills like this in years past, and what we tended to see in courts, especially 5 to 10 years ago, is the other side of this issue would begin their argument by saying, this is a case about transgender girls. And that phrase, transgender girls, which kind of assumes that we have a certain kind of gender ideology conception of what sex is, and the female sex includes both transgender and cisgender females. Once you start with that conclusion, that premise, you've built in the conclusion that separation based on biological sex has to be prohibited. So I think the reason is that particular premise, that gender ideological premise. And once you recognize that there is, in addition to gender identity, such a thing as biological sex, and that we've always differentiated between the two just fine in all kinds of contexts, then you can see that that premise doesn't make any sense.
Other questions? Seeing none, thank you very much. Next, I'm going to call on Taylor Main, please.
Good morning, Chairperson and committee members. My name is Taylor Main. I am a community organizer with the ACLU of New Hampshire, where I work with community members every single day throughout the state. I am here today because bills like SB 552 hurt the same New Hampshire families and community members I meet and work with every single day. Just this session, 5 other bills like this one have been introduced. And let me tell you, Granite Staters are exhausted. Parents with trans kids who I talk with are exhausted from having to defend their children's privacy from extreme legislation like SB 552 over and over again. Teachers and coaches that I talk with are exhausted from constantly having to tell lawmakers that their students' dignity matters over and over again. Community members are exhausted by discriminatory legislation being pushed from multiple angles instead of legislation that will help Granite Staters thrive. So today, that's why you do not see as many people in this room testifying, because this legislation is exhausting. 6 bills exactly like this means 12 hearings, all scheduled at different times. And frankly, it's insulting. Frankly, Granite Staters cannot keep taking time off of work, off of school, off of other caregiving responsibilities to continuously to have to sit in a room like this and beg for human decency from lawmakers who are supposed to be defending our rights. You would be exhausted too, and you would be insulted too. But don't mistake the lack of a huge crowd here today for any kind of complicity. If you reference the online testimony for this legislation, you will see that nearly 300 Granite Staters took time out of their day to register opposition, and that is 15 times as many people who signed in to support it. I want to be able to go back to the hundreds of community members who have told me time and time again that they are frightened and horrified by the impact of these bills, and I want to let them know that this legislation will not move forward. I hope that this committee can put an end to the exhaustion, to the fear-mongering, and to the insult, and help me bring that news to them. Thank you.
Thank you. Questions for this witness? Representative Perez.
Are you aware that the parents of young girls and the grandparents of young girls are also exhausted and tired of being fearful?
Yeah, thank you for that. The community members that I talk to again every single day, that's not what I hear from folks on the ground. I was also a young girl once. My mom was very protective over me, and that's not a concern that we ever had.
Other
Thank
questions for this witness? Seeing none, thank you very much.
Thank you.
Next, Hazel Kane, please.
Do you hear me?
There, yep.
There we
you
go. I thank the Honorable Committee for having me here today. My name is Hazel Kane. I am testifying in opposition to Senate Bill 552. I think we just have to get something straight. We have to tell it like it is. Trans women are women. Some women are born with brown skin, some are born with light skin, some are born with green eyes, and some are born with blue eyes. Some have uteri, some have vulvas, some have XY chromosomes and penises. And I'm going to be quite frank with you, and I apologize for who I will offend. If you are a woman with a vulva and you are uncomfortable seeing a woman with a penis, too bad. You have to get over it. There are women, white women, who are uncomfortable being around brown women. We did that a century ago with segregation, with Jim Crow. People decided that because you had dark skin, you were more dangerous, you were more likely to commit violent crimes, and because of that, you had to be cast away. You couldn't be in the same restaurant as a white person. You couldn't be in the same bathroom or the locker room. You couldn't even drink from the same fountain. And we're in the same era right now. You would think we would learn something, but apparently we didn't. We are saying somehow that because statistically people with penises and XY chromosomes tend to be more aggressive because those are men, that somehow a transgender woman falls within those statistical norms. By definition, a transgender woman is not within those statistical norms. They are going out of their way to take medications to reduce libido and aggression. They are altering their bodies to be incapable of penetrating a person. They are clearly not of the category that should be prohibited from these bathrooms. Some people are going to be uncomfortable. We cannot let their implicit biases, their irrational fears, their own trauma history take away rights that other people are entitled to under the law. We live in a free society, and that produces discomfort to it sometimes, and we have to accept that. I will gladly take questions.
Questions for this witness? Seeing none, thank you very much. Next, Tanya, oh boy, Tanya Kreger, I'm sorry. Thank you. Yep, press the button so there you go. Thank you.
All right. So I just want to address a couple of things right off the top, and I'll be really quick. First, on the matter of gender dysphoria being a mental illness, it is, according to the DSM, not considered a mental illness in the classical sense. So it's not. On NYC not doing gender reassignment surgery, they are. I have a consultation next December. I'm here to say just a couple of things. First off, I'm here to say that I'm a trans woman, but look at me, right? I'm not going to go into the ladies' room. I'm not, I'm very early in my transition, so I'm not going to go into the ladies' room, right? I'd make them feel uncomfortable. So I don't. But there are trans women who look a heck of a lot more like women than men. In fact, they're women, right? So I would not expect to see them in the men's room. So that's that's, you guys are legislating something for something that doesn't happen, okay? The other thing that I want to say is I really do have concerns about trans women getting sent into men's prisons, because it's a quick Google search, you can look it up. They're 6 times more likely to be sexually assaulted, and over 50% of trans women that are in men's facilities have been sexually assaulted. I'll take questions.
Questions for this witness? Seeing none, thank you very much, sir. Rebecca Hoskins, please.
Thank you, Mr. Chair and members of the House Judiciary Committee. It is good to see you all again. As you know, I am Rebecca Hoskins. I'm a lifelong resident of the state, and I currently reside in Concord. I've come to speak to you today to urgently oppose SB 552. This bill poses a great risk of harm to all Granite Staters. This bill and other anti-LGBTQ bathroom bans like it are not going to be keeping public or private spaces safe. In fact, bills like this make public spaces decidedly less safe. One of the reasons Governors Sununu and Ayotte have vetoed bathroom bills in the past is their inability to be enforced. How exactly are you going to stop all trans people from using the bathroom? Even if you believe someone is trans, you could be wrong. This was very much the case last year in Massachusetts when it was reported a woman using the bathroom in a Boston hotel was asked to leave by a male security guard. Let's just stop and think about that for a moment. Someone made a snap judgment about another person's gender and reported them for using the restroom. Then, a male security guard walked into the woman's bathroom, banged on the stall, and demanded that woman leave. As it turned out, the person who made the snap judgment was wrong, and that security guard had just harassed a cisgender woman. Are we about to make bathrooms in New Hampshire the Wild West, safe for no one? That story makes me fearful that something like that could happen to me if I were to use the bathroom wearing a suit. And in terms of sports, are we about to punish the one girl on the Concord High wrestling team? The rest of her teammates are male. She is the first girl to win the state championship 4 times. She is not trans, but she's a female on a male team. Would she not be allowed to wrestle people that match her weight class going forward simply because she's a girl? Furthermore, this bill only has a vague understanding of actual biological sex. Intersex people use the bathroom, play sports, and potentially go to prison. Bills like this always erase the existence of intersex people. If this bill became law...
Thank you. Thank you very much. Your time is up. Questions for this witness? Seeing none, thank you very much. Next, David Trumbull, please.
Good morning, Mr. Chairman and committee members. My name is David Trumbull. I'm from the town of Ware, and I oppose this bill. These bills all end up suffering from the same problem, which is that after questioning that you end up seeing they're based on stereotypes, that all transgender people are ill, perverted, definitive. Any action that's bad by one transgender person reflects on all transgender people. And that's ridiculous. Transgender people are real. Transgender women are women. Transgender men are men. And intersex people don't fit neatly into biological sex roles. I would encourage you to get to know some transgender people. If you're confused about this issue, that will probably help you alleviate many of your concerns. On to a few points. On the bathroom issue, fundamental rights are at stake here. And to take away fundamental rights, you have to have the least restrictive alternative. If you pass this bill, you should add an amendment that requires anybody who adopts this discriminatory policy would have to have at least one all-gender restroom. They're already in the International Plumbing Code, which we adopted a couple of years ago. That would be a less restrictive alternative. When it comes to sports, you should adopt a less restrictive alternative that any child who began taking testosterone suppressing medication for at least 12 months before they hit puberty, so a transgender girl could compete in the female division. They would not have gone through a male growth spurt. They would have no testosterone. They would have none of the competitive advantages. That would be a less restrictive alternative that would protect their dignity and their rights. The education factor. The law serves to educate. It's not just about making rules. Either you're going to educate our state that we should be bigoted, prejudiced, and stereotyped, or you're going to educate our state that we should treat everybody with respect and dignity. I hope you'll choose the second option. Thank you.
Questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Nancy Brennan, please.
Hi, thank you for taking my testimony today. Nancy Brennan, I'm from Ware, and I would like to piggyback on a couple of things that my friend from Ware just said. I didn't prepare testimony. I usually come with folders this thick proving that transgender people as a whole are not a threat. It always bothers me to hear Stacy Lawton's name over and over and over again among transgender women, among cisgender women, among transgender and cisgender men. Are there bad actors? Yes, but that does not equal that everyone is bad. And I too wish we could have conversations. I wish you guys would have some kind of a study committee. I have talked to people who have written these bills who have never sat down with a transgender person and listened to them. And I think that's a big problem because then we have it on one side, we think that all transgender people are evil who want to hurt somebody, and it just isn't true. And I really think a study committee is what you need. I think you need to talk to these people. You need to talk to parents of transgender people. I do not believe that harm is happening. I believe harm is happening in this country, in this state, mostly by men. We've all seen bits of the Epstein files, and we have people at very high levels hurting women, hurting little girls, and that's what we should be concerned with. not some trans woman who's just trying to pee. I have a friend who, when she gets to my house, immediately uses my bathroom because once she crosses our borders, she is afraid to stop at a public restroom. That's not who we are.
Thank you. Questions for this witness? Seeing none, thank you very much. Next, Sullivan Bono, please.
Thank you for hearing my testimony today. As many of the people before me have discussed, how would we enforce this bill? And I think from other people's testimonies, the answer has become very clear to me. Either an invasive measure or through visual profiling. And as many have said, this becomes a case of assessing when is feminine feminine enough? When is masculine masculine enough? We have no way of proving who is what gender identity based on visual profiling. And I think doing so is harmful both to trans individuals and cis women, because there are plenty of cis women who do not fit the mold of gender norms. And I'm sure there are many of cis men out there that do not visually conform to gender norms as well. And I think that when we're talking about protecting cis people, we should also talk about what can be done to protect those who visually do not conform to gender norms. And I think the larger goal of this bill, honestly, is to push conformity. Because if a person does not conform visually to gender norms, then they are under threat of being interrogated under this bill. And does not improve the safety of people at all under this bill, regardless if they are trans or not. I think that in terms of treating people with dignity, that is something that we should go forward with acknowledging that people have a right to have public access to bathrooms. I believe we should not make snap assumptions about people's gender identity and whether it or not it corresponds with their biological sex, because doing that can cause more harm than good. And as we have seen before, there are people that will go into bathrooms and make assumptions as such and respond with hostility, and then people get assaulted physically, sexually, as one has stated before, that trans women are very likely to be assaulted.
I'm sorry, your time is up.
Okay, thank you.
No, thank you. Do people have any representatives here have questions for this witness? Seeing none, thank you very much. I don't have any other pink cards. Is there anyone else who wishes to be heard on SB 552? Seeing none, I'm going to close the hearing on SB 552. Let me just ask, this is directed to the members of the committee. Are there any bills that would make sense to try to exec now? And what I'm thinking of in particular is 414, and my sense from the ranking member, and I think I share this, is that we both have some, I think, I'm speaking accurately, of some concern about whether this bill is really necessary and whether it accomplishes anything. And so I'm wondering if that is a view shared generally among the committee. And as I say, I'm not looking to, sort of force execing on this bill if people want more time or whatever. But if okay, all right, and
Well, we can discuss it. We can discuss it in session. She could discuss it in executive. She wants to talk about it.
Yeah.
Or do we?
Yeah, but once you're committed to it, it's for 60 or 75 seconds.
Sure. Yeah. No, that's fine. That's fine. So why don't we we'll recess for about 2 minutes or so, and just again, as I want to emphasize, if there's any, unless we have real consensus, I'm not proposing to.
Do you have any idea of how many other bills we are going to get after today?
I do, and I think right now we don't have any other bill. We may get, Representative Kutab tells me we may get a couple of more. So there is no, we're not under any time pressure at all. But
Mr. Chair, we have from now through April, good part of May to do these things.
Now through April. The deadline's May 7th.
Excuse me, what?
The deadline's May 7th for everything, but one of these bills, the deadline is actually April 16th.
But even that, we still have
So
plenty
we have
of time.
time, so if people want, I don't want to be the only one, but I like being together with members of the Judiciary Committee, and I like hearing how people bring different perspectives to the bills. And we have a chance here not to rush the way we rushed through all of the House bills. So I would ask that we
Not do this today.
recess now and that you schedule another meeting for us. Perhaps you might want to wait until you see what bills come tomorrow, and then we could do all of that at another table. But if I'm the only one, please, I'll go along with the majority.
Representative,
problem ceding to Representative Smith.
Representative Perez.
I, on the other hand, say we are here. We are trying to plan our lives, which we could not plan in January and February and the beginning of March. So therefore, I think if we can come to a consensus on at least one of these or two of these, we should do it now.
All right, well, look, no, I appreciate what you're saying, Representative Perez, but I do think that we're not under time pressure, and if we have some objections to moving forward, I think it makes more sense to just hold off.
Add a third day. That way we're not adding any additional days. It'll only be one more to add a third day. That way we're not adding any additional days. It'll only be one more day. Take a look, see if you might want an amendment, and then we could take action.
Yeah,
Would
no,
that work?
I think that makes sense. So, yeah. So what I'll do is, hopefully the other two bills or whatever, we'll have them by in time to schedule a hearing for, let's say, next Wednesday. Hopefully next Wednesday, if not the Wednesday after. Oh, not next Wednesday. Not next Wednesday. No, not next Wednesday. So 2 weeks. Next, well, it's Passover.
Yes.
By next Wednesday, you will know.
I should know
all
what.
the bills
Yes,
will be, so.
we can schedule
Put it on the calendar for
the following week. Right.
Out of respect for Holy Week.
Yeah.
We need to not have a very Holy Week. If we're going to respect Passover, we need to respect Holy Week.
Well, we just said we're not. We just said that we're not coming until April 8th.
Right.
And that would be the deadline for one of these bills, basically, because we're not going to wait until the very last day because the
Right.
reports would be due by noon. One of these bills is in fact due out by the 16th, so that would mean April 8th, we have to come in.
Okay.
Correct.
Right. So yeah,
That's
so that's good. All right.
Do we,
Representative Hort.
do you anticipate many bills coming in which are amended by the Senate? And then, yeah, actually yesterday, I mentioned the Senate had a hearing on one of our bills, which passed on consent, but one of the members of the Senate Judiciary Committee is using it as a vehicle for a non-germane amendment. So do you anticipate many, like?
I don't. I honestly don't know right now, but we'll find out. That's for
I
sure.
took upon myself, just as, because I was at the hearing, and I was just speaking strictly for myself, that I would prefer that they not put on the non-germane amendment, so the bill in question could sail through the Senate as it sailed through the House and be signed by the governor. But whether or not to do that, that's up to them.
Yeah, no. Both sides have played that game, I have to say.
Oh, sure,
So,
yes.
All right. So in light of that, I'm going to restate.
Got very nice honor from her award from her community.
No, tell us, please tell us about it. Tell us.
Very surprised.
Oh, tell us what was the award?
I guess it's because I work so hard. I mean, I may be quiet in here, but outside in here, I'm not quiet.
All right. Well, congratulations.
So her committee made her.
Oh, that's great. That's great. Well,
Very surprised.
Congratulations. That's terrific. All right. So we are in recess and the next meeting to be determined. Thank you.
Until next time. Thank you. You should ask about it.